concerns increased and led them to conclude that the balance between public risk and private profit was out of whack and needed to be altered.
What happens now with the project? What happens now?
Well, that's up to the project planners to decide. The commissioners are identifying for the court, having been sued by the authority and principal parties, has identified why they were taking the steps and the fact that the guarantee agreement with the county was signed in violation of the ordinance back in 2000.
Can you explain this note for one moment? It's in Citizens Bank and it's as a note for, I guess, $39 million? Is that
$40 million.
$40 million. And to remarket the bonds would be from this note, I take it, for the construction. Can you explain that a little bit?
Sure.
Okay.
What happened in 2003 is that the Convention Center Authority wanted to create artificial debt to which the county would adhere its guarantee. So that at the time the authority really needed to borrow money to fund construction, the county guarantee would already be in place. The reason it did so back in 2003 is that the outgoing Board of Commissioners had 2 votes to do so, and they knew that all of the candidates for the incoming board would be opposed to it. And so they adhered the debt at that time. It's been there now for 2.5 years, costing taxpayers $1 million.
Howard, would you say and spell your first and last name?
Sure, Howard, Howard, Kelin, Kelin.
Very much. Thank you, Howard.
Fenningham, Bucks County, Kansas. Excuse me, let me get it.
Sorry, spell Fenningham for us.
Fenningham.
Now, specifically, you are representing the authority, correct?
My client is the Convention Center Authority.
But Rackle and the Pittsburgh partners are also listed on this, correct?
ESP and Rackle filed a lawsuit. The authority then filed its own lawsuit. The authority filed a motion to consolidate the 2 actions for economy.
How did you think it went? How did it go today?
I think the judge was very receptive to both sides. He listened carefully. I think we presented the facts that we could through the witnesses, and I think the case went in well from the standpoint of presenting the judge exactly what the issues are.
What were your main points to get through today?
That the guarantee agreement is valid today as it was in 2003, that there is no variance between the Ordinance 73 and the guarantee agreement obligation of the county, that the county embraced that obligation all through the period from 2003 to May of 2006.
In your own words, Resolution 36 and 37, why did they ever even come up with that?
Because every other step to oppose the project failed. So it was the next step. If you understand that May 3, the Commonwealth Court issued its decision denying the appeal of the DCED action under Act 23. The next day, Commissioner Henderson announced her plan to present Resolution 36. We think the timing of that is clearly obvious. And Commissioner Shaw testified that he believed, at both his deposition and in court today, that each of these steps are part of an overall strategy to derail the project.
And do you feel like you prove your client had clean hands as Mr. Kelin was trying to prove otherwise?
The authority is an instrumentality of the state. It's exercising powers of the Commonwealth under the statute that defines what the authority is supposed to do. The authority has a single statutory mission to proceed with this project, which it is doing.
Commissioner Shaw said it's sometimes hard to quantify exactly how detrimental some of the things can be. Do you think you did a good job of showing that there's a negative atmosphere about this project right now?
We think we did. We think we showed the judge the requisite facts to support a legal finding that the damage to the authority and to the project and to this city and county would be irreparable, that you cannot calculate it in terms of money damages, that what we are actually saying to the court is that we will lose a business opportunity to proceed, and if we lose that, then we can't proceed.
Commissioner Henderson kept saying that she was just trying to protect the taxpayers. What's your response to that?
I asked her on cross-examination whether she understood that the guarantee agreement was capped from the very beginning, that it set a very limited obligation of the county. That obligation was not expanded. We have offered as an authority to prioritize the use of the hotel room rental tax. The financial advisor for the authority explained very clearly, in fact he answered questions directly from the judge, that the desire was to maintain the greatest flexibility for the remarketing of the bonds. But he also testified that when those bonds are remarketed, the use of the hotel room rental tax would be prioritized to cover the debt service. There has been no dispute about that.
Do you believe Molly when she says that she didn't even consult with her own financial advisor in the county like that? Do you find that suspicious and then go into Resolution 36 and 37?
I only can tell you what you heard and what I heard, and her testimony was that she did not. I believe she testified that she relied on other folks whether they had the appropriate expertise, whether they had the appropriate goals in mind, in the fact of the advancement of the project for the benefit of the county and the city, or whether they had political agendas, I don't know. I can't grant an opinion on that.
What happens to this project if the judge rules in favor of the county?
It's still undetermined. There's certainly a process of appeal. Because my client has the statutory mission, the authority could certainly review this and vote, but they have a single mission. So if they believe that the agreement should be enforced today as it was in 2003, then they very well may consider an appeal.
Thank you.
Time, of course, is of the essence for all the reasons that we all heard in the testimony of the witnesses.
So you'll come back on Monday, that's at 10:30, you'll just do closing arguments each, and then that's it?
That's right.
And the judge will likely not render a decision from the bench?
It's hard to predict.
Okay.
He may make a decision from the bench. He may ask to have a few days to consider our
And then that's a written opinion to you?
My expectation is the judge would issue some written opinion